Good afternoon. Thank you for joining us today for our business hour, How To for Employers, Leaves of Absence and Reasonable Accommodations. This is the third in a series of how-to sessions designed to provide practical strategies to handle tough employment issues, including advice and solutions on real-life compliance issues. I'm Miriam Rosen. I'm a member of our Labor and Employment Group, and I'm located in our Detroit office. And with me on the panel today is Victor Geraci and Nicole Gray from our Cleveland office. Both of us all three of us, spent quite a bit of time dealing with these issues of leaves of absence and reasonable accommodation. And we know how difficult, frustrating, and challenging they can be for employers. And hopefully today we'll give you some practical solutions that'll be helpful to you in dealing with these truly difficult issues. I know that you've each gotten, here in Cleveland, cards. If you have questions, someone will pick them up if you raise your hand. For people on our national webcast, you can use your computer and submit questions. And if you've submitted questions in advance, we'll try to address them throughout the program. So let's get right to our topic, because we do have quite a bit to cover in, frankly, a short amount of time for this really difficult topic. What we want to do is give you a little bit of background on the law, just a little bit, and then really talk about some real-life situations that we've faced, and hopefully get your questions, input, and give you some guidance. So just kind of to set this up, as I was thinking about this, in the 25 years that I've been practicing law, the leaves of absence, reasonable accommodations, have grown exponentially. As a matter of fact, Victor and I were talking about the fact that when we started practicing law, this will date us a little bit, the ADA and the FMLA were not even laws. And we had real easy solutions for issues like reasonable accommodations, which certainly would not fly today. So if you're feeling confused and frustrated about these laws, what you should know is you're definitely not alone. A SHRM survey, Society of Human Resource Management survey a couple of years ago found that 7 out of 10 HR professionals were frustrated by issues relating to tracking and documenting FMLA leave, medical certification, and the big one, of course, suspected abuse. Those issues, some of which you also see on the slide here, including the expansion of disabilities. Again, years ago, disabilities were pretty contained. Now, almost everything's a disability. If you've been watching the news, you see the American Medical Association wants to consider obesity a disability. In another seminar, we recently talked about internet use disorder as a disability. So, you can see why it's so difficult to deal with. So certainly all of these things make this issue very challenging. A couple other things that I think make it challenging are the fact that HR professionals who don't have a medical background are asked to look at medical documentation and make judgments about how to handle situations. Also, typically, employment law, HR, the guidance is be consistent, treat everyone in the same way. But really, because every disability is different, the guidance from the EOC is do a case-by-case analysis. So it's kind of inconsistent with how HR professionals look at things. And certainly we know there are many, many employees who need leaves, have legitimate conditions, but unfortunately that small fraction who abuse it and submit fraudulent information make it difficult for everybody. Let's do a very quick refresher. Family and Medical Leave Act. Federal law, which requires 12 weeks of leave in a rolling 12-month period, and continued health insurance. One of the questions we got was who pays for that health insurance? The employer is responsible for continuing their contribution, pre-leave contribution, during the FMLA period. Under the FMLA, leaves can be taken intermittently, on a reduced schedule, or on a continuous basis in a block of time. If the condition meets the requirements, the employee can't be required to work during an FMLA leave period. And the FMLA is enforced by the Department of Labor, which also enforces the Fair Labor Standards Act. In contrast, the Americans with Disabilities Act requires no discrimination of disabled applicants or employees and reasonable accommodations of an employee to perform the essential functions of the job. That's pretty key. Sometimes we leave that out. It's to help the employee perform the essential functions of the job. Accommodations can include a modified work area, modified schedule, changes to policies, leaves of absence, which Nicole will talk about in greater detail. And interestingly, the employee might not get the accommodation they want. That depends on what they need to help them do the functions of the job. So that's a little difference between the FMLA. If the doctor says an employee needs to be out, you can't really push back and say, well, couldn't you work part-time? So we have a little more flexibility, surprisingly, under the ADA. Unlike the FMLA, the ADA does not have a set time limit on the length of leaves, which Nicole will talk about in greater detail as well. And the Americans with Disabilities Act is enforced by the EOC. So again, different federal agencies. One of the other questions we got is, are there comparable state laws? And yes, many states have laws comparable to the Americans with Disabilities Act. Some states, not all, have their own state FMLA laws. If you're an employer with over 50 employees, you're covered by the FMLA. If you have over 15 employees, you're covered by the Americans with Disabilities Act. So now that we understand the two big statutes, right, completely understand them, let's jump into some of our substantive issues. If only it was that easy, right? Our first issue, the one that we've all dealt with, and I'm sure you probably have dealt with, is notice issues. I kind of wanted to call this, how do I know? And I wish I could tell you that there was a bright line for knowing. Unfortunately, there's not. Unlike some of these other statutes, the FMLA actually has several employer notice requirements that I just wanted to review quickly so you're reminded of them. Because these are the type of technicalities that if you have a complaint, the DOL will certainly focus on. Technicalities are always easy targets for federal agencies. So there's a posting requirement. If you have an employee handbook, which most employers who are covered by the FMLA should, you must have an FMLA policy. You can include an FMLA policy in your handbook. Then, as you know, the FMLA has certain procedures you have to follow for an employee to get a leave, and I look at those as notice requirements too. So if an employee communicates that they may need a leave for a serious health condition, the employer is responsible for providing the notice of eligibility and the rights and responsibilities forms. The request for medical certification form, now you could put that on a website and let the employee get it themselves, but as the employer, I usually like you to have control of that so you know who's getting it and when they're getting it. And then once you get documentation back, you have the responsibility of designating that time off as FMLA leave. And some employers forget that last step. We're going to talk about documentation, and I'll talk about whether you should use the DOL forms or not, but those are what I would call the employer notice requirements. But what about the employee notice requirements, the bigger issue? How do you know? Again, the regulations have some pretty specific timelines. If the leave is foreseeable, the employee has to give you 30 days advance notice. We all probably know that doesn't happen all that frequently, maybe it's planned surgery and pregnancy. Most leaves are probably unforeseeable. The employee has to let you know as soon as possible, which the regulations say means the day the employee knows or the next day. Prior to modifications to the regulations, there used to be a 2-day requirement. That's not the law anymore. It's the day the employee knows or the next day. So, as you're looking at your FMLA policy, if you're updating it, that might be something you want to put in there. Now here's the kicker for an employer. Notice can be verbal or written. It doesn't have to be in writing. You can require the employee file your policy, but truly, if they don't, you can't deny FMLA. Employees are not even required to specifically mention the FMLA, at least initially. So that's where the employer's understanding what the employee is saying and training managers who are probably getting that communication to understand is so important.
And Miriam, just to comment on that, I've had a lot of employers who have said to me, well, they never said they wanted FMLA. And the fact that they didn't use those words or refer to it as FMLA, if the employer has reason to know that this would be an FMLA covered absence, the burden's on the employer, not on the employee. So I just raised that because I know I've had a lot of clients that give that as the response.
Right, and the other issue that comes up, quite frankly, is that the Department of Labor has a view of the sort of information that you as an HR professional receive from employees and make an assumption about the fact that most of the time that information is complete. In fact, it's the opposite. Most of the time the information is incomplete. It's vague. The diagnoses never really fit exactly the way they should under the definitions as they exist in the regulations. You're required to ask a lot of questions. You're required, under the law, unfortunately, to have enough foresight about medical issues that you're really not trained on, to ask the right questions and to probe medical documents to ensure that they say enough to allow for you to do the planning that you need to do to run your business. And so most often we'll get FMLA written responses where someone will say that people need time off to visit a doctor, or there are intermittent issues that come up with acute flare-ups of chronic diseases, for example, of arthritis or of fibromyalgia or of diseases like that that are not a flat line sort of symptomatology but have different variations. And so it's very difficult to sort of put all that together, but it's important that if you have a policy that you basically are as consistent as you could be, that you have as much in writing as possible, even though the regs don't require the request to be in writing. We're going to require it because as your lawyer, we need to have evidence of what happened, and the written documentation is the best evidence, especially months or even years sometimes after the fact.
So again, and Victor's explanation goes to why you need to have some procedures in place for requesting leave, even though you may not be able to say, I didn't know about it if they don't follow those procedures. So really, what's the issue? When has the employee given you notice? And I want to tell you what the FMLA regulations say about that. Here's what the FMLA regulations, the DOL has to say. Where an employee has reason to believe that an employee may be absent for an FMLA qualifying reason, the employer must inquire further to determine whether the employee is seeking FMLA protected leave. So you see the regulations put the burden on the employer to ask questions. So, what we really want to do here today is talk about some situations. And my scenarios that I'm going to talk about today, and I think everyone else's, are real life scenarios because we can't make this stuff up. So employee sees the dentist on Thursday and is off work on Friday and Monday. Returns on Tuesday with a note from the dentist that indicates the employee is suffering from pain due to dental work. Well, the employee had pointed out. The employee never even got to the HR person, and there are a few more complicated facts in this true situation, but I was trying to pare it down here. Employee never gets to HR. The supervisor says, you pointed out, you're fired. Well, we've got a medical appointment. We've got an employee who's out, and you might say he's not out 3 days, but Friday, Saturday, Sunday, Monday, days, even if they're not work days, if you have a serious health condition that lasts more than 3 days, it could be covered by the FMLA. We don't know really, but we know he was allegedly out due to pain on Friday and Monday. So who has the burden to make some inquiries about this situation? Employer. I see some people pointing at themselves. Employer, you need to at least do a little delving. We don't know from this whether it's FMLA or not, but what we do know is we need to ask about it. And I'll just give you a little postscript on this. Again, my situation was a little more complicated. Employee was terminated and made a complaint to the Department of Labor, and the Department of Labor said absolutely he's covered. And we ended up resolving it with the employee. So, and they were not taking any pushback, they were convinced he was absolutely covered. This isn't going to make you happy, but I want to give you an example of why this is so frustrating. Scenario number 1, employee sends a text message indicating that she's in the emergency room with her father. Employee's terminated for attendance violation, files an FMLA lawsuit. Court says, not enough information. The employer didn't have any reason to know. Situation number 2, which is a case that just came out a couple weeks ago, employee reported that she was currently in the emergency room with her mother, had been brought to the hospital via ambulance, that she was unable to work that day. In this case, the court said, employer, you have sufficient notice. Now, of course, it's kind of scary as an employer, isn't it? How do you know? Obviously, both cases have a little bit more of a backstory, and in one case, the employer knew some additional information, in the other one they didn't. Some of it depends on the court, but this is really to illustrate, employer, when you get that information that seems to tie it to a health condition, ask some questions. I wish I could give you a bright line on this, but we can't. So the idea is, employer, if you've got it, if someone's telling you something's related to health, you don't even need to necessarily give them the FMLA paperwork, but ask some questions to determine if it's necessary.
And scenario 1 seems to go more towards the idea that if somebody just calls off sick, that may not be sufficient notice that FMLA would come into play.
So let's jump to the ADA, because we have notice issues there too. Posting, no requirement for a policy, but some more, frankly, I would say a little bit heavier requirements on employees under the ADA. So the ADA regulations indicate that the employee has to communicate the need for an adjustment or modification to the work environment due to a disability. So again, you see some examples that make that distinction. If I'm telling you I need an adjustment because of my condition, well, then employer, again, an obligation to explore whether a reasonable accommodation is necessary. You can see an example 2. My chair is uncomfortable, but I'm not tying it to a medical condition. Why would you ask more? You're not obligated to ask more. Of course, we all know what happens, because when the employee complains or is fired, he's going to say, well, I told you I was uncomfortable because I have a bad back, or you knew I had a bad back. So.
Right. Just getting back to example 1 there, when it talks about difficulty getting to work on time, or they need to schedule their work time differently because of medical treatments. Generally speaking, there is someone will come up with excuses about why they can't come to work on time. And more often than not, because of the expanded definitions of disability, they could find some way to work their tardiness into some medical sort of issue. One that comes up quite often is in the mental disability area, where people are either under treatment for depression or have been diagnosed for depression, and then take medication, either sleeping pills or other medication, as part of their treatment regimen. And then they complain, for example, that they can't work at 7 a.m. because their medications require that they have some time to work themselves into the day, essentially. That sort of problem is coming up more often. The courts have been sort of split on that, essentially saying that you have, as an employer, the opportunity and the right to determine when the workday is, but also saying that when you know of a specific disability, that you have to be cognizant of the potential side effects of certain medications, and especially when people report what those side effects are, that you have some reasonable requirement to accommodate some of these side effects. And now, given what we've said about how these issues come up in the workplace, and the fact that sometimes employees aren't as clear as they should be, you generally find out about the issue after the discipline process has begun. Once you start in on tardy discipline, you start in on absentee discipline, Then you find out rationales for why it happened, and now you have to figure out what to do going back, and that's very complicated.
Yeah, actually,
sometimes.
in this little next scenario I'm going to give you ties right into what Victor has mentioned. So, as you see on this slide, one question I get a lot is, should I ask if they need an accommodation? And unfortunately, the answer again is it depends. Here's the guidance from the EEOC on when you should ask. You know the person has a disability. The employee appears to be experiencing workplace problems because of the disability. The disability may prevent the employee from asking. That comes up, I think, less frequently. You know, this last point, though, which is in the ADA regulations, I think is interesting, or the EEOC guidance on the ADA. If the individual with a disability states he or she does not need a reasonable accommodation, the employer has fulfilled its obligation. So sometimes you go to the employee and ask, they say, I'm fine. You don't have to keep asking. Of course, what do you want to do? Document that you've addressed the situation. So here's a little scenario. The employee has attention deficit, mentions attention deficit, and then is disciplined. In the discipline meeting says, oh, it's because of my attention deficit. What do? Just keep going? What do you? Well, again, this is a real scenario. And the way we've addressed it is to say, look, you didn't request an accommodation, so we're going to issue this discipline, but going forward, we are going to work with you to identify a reasonable accommodation. What I always have my clients do is make sure it's clear to the employee, though, you still have to be able to perform the essential functions of your job. A reasonable accommodation is, not a get out of your essential functions free card. It's a how can we help you do your essential functions. All right, we're going to run through documentation of FMLA and ADA leaves. So again, the way you get appropriate information is by using the medical certification form for the FMLA. I'm sure you all know that the Department of Labor has a template form that you can use if you choose, but you're not required to use that template form. And so what I would say to you is go read that form, because it doesn't ask questions in a very logical way. And you may want to think about working with counsel to develop your own form that asks questions in a way that, same sort of questions, but ask them in a way that gets you better information. You can also, in terms of documentation, you probably all know, I think Victor and Nicole, I'm sure will mention this too when she talks about fraud and abuse. Those forms, the doctors are spending 2 minutes filling them out. You don't get very good information. Read it really carefully. If you don't like the information that you've received, go back and tell the employee why it's unclear or insufficient. I have my clients use a designation notice to do that, but there are all kinds of ways to do it. And then, once you've given the employee an opportunity to correct any problems, you can contact the healthcare provider to authenticate, to get clarification. So, the regulations indicate a key part of the process is getting the correct forms. So I have a little example here where the employee got a form that was, the employer got a form that was inconsistent. So migraines that may result in intermittent short-term disability, but the form also said no when asked if the employee had to work intermittently. Well, you could just take that and say, well, it says intermittent short-term disability, but it also says no. So what I would do is get clarification on that. I would use a designation notice to inform the doctor that, give it to the employee, inform the doctor that we need clarification. And when you're doing that, the employee has 7 days, not the 15 days, 7 days to get that information back to you. And one of the questions we got was, should we tell the doctor to send the forms back to us directly as opposed to going through the employee? Now, you can. I don't prefer that because I want to place the burden on the employee of getting that form completed and getting it back to me. I don't want, as the employer, I don't want you to take on any additional burdens, being responsible for that, tracking it down with the doctor. That's the employee's obligation to get you that paperwork. And if they don't, there are plenty of cases where when the employee hasn't provided the appropriate paperwork, the employer has been justified in terminating, of course we'd want you to seek counsel before you did that, but it's the employee's obligation. Another quick one. So the employee submits, and this is true, employee submits 4 FMLA medical certifications. So right there you know you have trouble. One of them said the employee had arrhythmia and couldn't work. Well, first the employer said she could work, or the doctor said the employee could work. Will the condition cause episodic flare-ups? No. What did the employer do? The medical certification, in fact, wasn't unclear. It was very clear. They denied it. So the employee came back with a form that said, yes, it will cause episodic flare-ups. Well, now it's just unclear, isn't it? We need clarification. So I guess what I want to stress here is really look at that medical certification and get good information. In this case, the employer used the follow-up and then ended up contacting the doctor, and the doctor made clear that the employee didn't need to be off work. What happened between the first no and the yes? The doctor was succumbing to the employee's pressure to say she didn't need to work. But when pressed, the doctor gave the truthful information.
It's also interesting, and you note that the employee went to the emergency room during one of the episodes that he or she had at work. And in that situation, it's a little easier to deal with because they went to get medical treatment. There's some documentation as to what happened at the emergency room. The doctors would have to put some sort of diagnosis down as to what occurred there. But sometimes in the situation of a migraine, for example, the individual could just go home. So now they don't have any medical documentation as to treatment received on that day. They may not have treatment within a few days, except for a statement from a doctor that they're being treated always for migraines. And it raises the question about whether that particular leave, which you didn't have notice of ahead of time, was something that should have been allowed under the FMLA.
Right, another particular tricky issue there is when did it start? If the doctor didn't see you till 3 or 4 days later, so you sometimes need to press the doctor about when did this condition start, even if the employee didn't see you for several days, and we can all see how that could happen. You think you're going to get better and you don't. I want to talk about the ADA documentation. Unlike the FMLA, there's no set form. There's no medical certification form. I would recommend as a standard practice that you have a set of questions that you're prepared to ask doctors. Lots of times I hear employers say to me, they get some note from their from the employee, and you'll see a couple of those. I think I've included in the next examples. But I can't ask any questions. It's not a HIPAA violation as the employer, and here's the EOC enforcement guidance. You can ask for reasonable documentation about the disability and functional limitations. If an employee needs an accommodation, you can ask some questions. Here are the questions. This is right from the EOC guidance. Nature of the disability, the functional limitations, the need for a reasonable accommodation, the types of accommodations that assist the employee in performing the essential functions of the job. Who can you get this documentation from? A healthcare provider or rehabilitation professional. So unlike the FMLA, you can actually make it a little less broad. The FMLA has pretty broad categories about who's a health care provider. The ADA doesn't. So I want to give you a couple. These are, I think, kind of funny examples, but I think they will drive home the point. And again, I couldn't make this up. This came across not great on the slide I see, but this was a real note that one of my clients got. Attached is a note from my massage therapist regarding the back problems I've been experiencing since starting my position. He recommends a specific model of stand-up desk. So what do? You rush out and buy that desk? What do you do, Nicole?
I actually had a similar situation come up where the chiropractor requested that the employee get a specialized chair. And this was an employee who had asked for a chair the last 7 years. It was always a new chair, and the employer had just always bought her a new chair. So we pushed back and this time and said to the chiropractor, well, why does she need this specific chair? And here's the chair we bought her last year. Is that sufficient? will that satisfy as a reasonable accommodation? And in that circumstance, it turned out that the chiropractor sold the chair and thought everyone in the workforce should have the chair. So.
Well, it's interesting because that's what we did. We pushed back and said, well, here's a whole list of questions we have about your back condition, including, can you just get up and walk around? Will that be sufficient? Because there was a person who was in a job who could do that. And by the way, we're not accepting a note from a massage therapist. So she came back and asked if we would accept a note from a chiropractor. We said, okay, but guess what? The employee never brought anything back, and apparently she's still working at her regular old desk. I see there's a question. If you want to write it down, we'll address it. And I just had to include this one because I don't know if there's a better example of not enough medical information. This is a real note, again, a real note that one of my clients got. Mr. Smith is currently under my care for obstructive sleep apnea. It may cause Mr. Smith to fall asleep. Please excuse Mr. Smith. If you have any further questions, don't hesitate to call me. Verbatim, other than it wasn't Mr. Smith. My client, as you can imagine, called and was outraged. Are we supposed to let him sleep on the job? What, you know? So, hold on. Let's get some documentation. Or before we even got the documentation, what we did was go to the client and say, or the employee, and say, what is it you want? Because you can't sleep. Sleeping on the job is not an appropriate accommodation. Let's say that. So in that case, they actually were able to work it out even without going to getting the documentation. But if we hadn't been able to, what we would have done is use our standard set of questions, submit it to the doctor, and say, what accommodations can we provide that will allow him to do his job? And I felt like this was a good one to end this documentation part on because it kind of dovetails right into Victor's comments on the interactive process. And that's exactly what we would have had to do, or actually what they did do. They just didn't need medical documentation, in this case for the employee who had sleep apnea. And in case you're wondering what the accommodation was, they got him a fan. It helped keep him awake. So, you know, sometimes when things seem overwhelming, solutions aren't that difficult. Victor's going to talk about those solutions.
Right. Under the ADA, and it requires that you have an interactive process with the employee. And over the years and through a series of litigations, it has been determined that you're required as an employer to communicate with the employee about the actions that you can take as an employer to make sure that the employee can perform the essential functions of a job. Well, it sort of leads to a whole bunch of other questions, but it's absolutely important that as part of your normal HR practice, you have job descriptions that clearly delineate what essential functions are for a particular job. Because invariably we get into fights about what the essential function was, and then after that, you know, whether an accommodation can be necessary or should happen. The interactive process is essential. Do not react without engaging in the process to evaluate the potential accommodations. Well, how much is required of you as an employer? When we say that there has to be an interactive process, you need to assess what the condition is. You need to ask the employee, what is it that you have that requires some sort of change to the work process. You need to obtain the necessary medical information, and you, with the employee, should identify or attempt to identify potential options for accommodations. Now this gets very tricky because especially in areas where some medical information or medical knowledge is required, you may not be equipped to make the kinds of decisions that are necessary. Just going back to our example earlier about an employee who states that they have a mental disability. Their mental disability requires that they take medication. The medication has a whole series of side effects, one of which is grogginess in the morning. That employee presents to you and says, I can't work until 9:30 every morning because I just can't focus mentally until that time. And I would ask that I be able to work from 9:30 to the end of the day, regular hours. What do you do in that? I mean, do you have to just believe them when they say that they are on a particular medication and the medication has a certain side effect? Are you required to go through a process of investigation? It gets very complicated, and all the more so because if you look at the most recent statistics, the most common ADA sort of accommodation or illness is back injury or back sprain. The second most common is mental. And under mental is depression, the whole slew of different diagnoses, whether it be ADHD or others. And the third is a neurological sort of problem. So between those top three, you have a whole series of potential ailments that involve very subtle symptoms that are very difficult to figure out in terms of potential solutions. It's important that your managers understand that they have to work with HR to come up with a reasonable process. What sorts of things are we talking about? Some of them involve telecommuting, flexible scheduling, adaptive equipment, changing locations, modified policies, sometimes even a temporary job coach or extended leave of absence. Let's get to an example. Employee who is a single mom reports that she has a child with asthma, allergies, and difficulty breathing. In the spring, the employee comes to you and asks for 12 weeks leave because the child has a flare-up of the asthma and is required to have inhaler treatments every several hours, and that necessitates the parent being at home to administer those treatments. The paperwork on that issue is appropriate. The child actually has the treatment. There are medical documents to support all that. However, at the same time, the mom has an immune disorder that requires that she work in an environment that is very warm based on the fact that her hands become cold and she cannot function either typewriting or doing other things. So what we had was a situation where an employee asked for the time off in spring. The child is off of school, the mom is at home taking care of the child. Then summer comes and the single mom presents to us a demand for medical leave based on the fact that she is having a flare-up of her medical condition, her immune disorder, and that she needs time away from the workplace, or we have as an employer to keep the workplace at 85 degrees or higher. This particular workplace was a physical therapy treatment center, and one of the concerns that they had was, well, if we keep the temperature at 85 degrees or higher, we have a whole bunch of equipment that could potentially become more infused with bacteria, et cetera, and would also be an uncomfortable place for our patients to come and do their physical therapy if we kept it at that temperature. So we had to work through a very detailed interactive process on the question of whether a leave was appropriate. And so the question became, what makes sense from the standpoint of a leave? But what did we have to get through first? We had to get through the whole HR suspicion that this individual wanted the summer off to be at home with their kid, right? I mean, that was the immediate concern was that the individual was not providing accurate information. Anyway, on this whole question of leave, when it came up originally, the ADA reasonable accommodations involved wheelchair ramps, different computer stations, what I would call physical changes to the workplace. Now, however, because of the huge increase in what I would call mental disabilities, the focus has shifted toward leave policies and whether an appropriate leave is effective. And here's the analysis from the employer's standpoint. It's an important takeaway. The ADA requires that you attempt to accommodate to return the individual to work and with the ability to perform the essential functions of the job. You have an employee with a mental disability or fibromyalgia or some other type of sort of flare-up disease, and they ask for leave. You need to determine, along with the medical provider, whether the leave will be effective in allowing the employee to come back after the leave in a condition that allows them to do the essential functions of the job. And that's key, because there's really no position anywhere where time off doesn't help you in some way. We could all use time off, right, Mary? I mean, it's just literally the case. We would feel more energized, we would feel happier if we didn't come to work.
Yeah, you know what I would say about the interactive process is this. Looking at the cases, and there are a whole body of cases now out there, employer, and I know that being HR professionals, employment lawyers, that there's a ton of pushback from the business people to say we can't do this. What I always say is, let's go through the steps. Maybe we can do it. Maybe we can accommodate sleep apnea. And if we can't, then we'll know and we'll be able to show that we did everything we could. Because sometimes you truly can't and you need to put someone on a leave, and either they're going to get better or they're going to have to end their relationship with you. But where employers win these cases is where they can show that they really were patient and took the steps to document that I looked into whether this person had an immune disorder, and here's how it negatively affects my business to keep the temperature at 90 degrees. I had a situation where a nurse had a fragrance allergy, some sort of condition where she couldn't be around scents, and she wanted the doctor's office actually posted a notice saying, please don't wear scents. When they sent out notices about appointments, they included that. So they were taking steps to accommodate her. But people forget, and sometimes people showed up with fragrance on, and she asked that they send those patients home. Was that a reasonable accommodation? No. But why was the employer in that case in a good position? Because they could show everything they did before that to reasonably accommodate. And this is what they also did. They said, we really value this employee. We want to offer her a different job where she doesn't come in contact with patients who may forget. And she turned it down. And what do we learn right off the bat? If the employee rejects the accommodation, says I don't need something, well, the employer's met its obligation. So, of course, you want to document that. So I think that all goes to the steps you can take to show that you're engaging in that interactive process.
Well, and another takeaway from the EEOC's perspective is that employers do think out of the box during this interactive process, that it's not just the typical, can we modify your specific workstation? Can we modify your schedule to accommodate the morning or leaving early for a doctor's appointment? But that the employer actually engages in a discussion of a wide variety of possibilities to see what can be accommodated.
We have a question from the audience, and it states, how do you determine what is considered a reasonable accommodation? And we've given some examples, and we've sort of worked through the process a bit. There's no set answer as to what exactly a reasonable accommodation is. However, it is, you need to gear it toward allowing the individual to perform the essential functions of the job. So you have to define what those are, and then you have to craft a solution to the problem such that the individual can, with the accommodation, perform the essential functions. And when do you state you can no longer accommodate an employee? That question sort of gets to the whole question of the reasonableness and when it becomes an undue hardship. For smaller employers, long leaves of absence, where you need to hire someone to take that individual's place, or you need to permanently reassign someone to do that individual's work, is, in my view, an undue hardship. circumstances where you need to either move someone out of a position that they had earned or move the employee into a position that is considered to be, for example, a preferred position, may be an undue hardship. I do a lot of work in collective bargaining situations where employers are, they have labor unions, they have a contract. Almost all the contracts have some sort of easier position, especially in the manufacturing context, for some of the older employees. So as they get more seniority, they move from the physically harder jobs to the physically easier jobs. Well, what happens when you have an individual asking for accommodations based on a physical issue is that sometimes they will ask for that preferred job, and they will ask specifically to bump the individual who's in that job in order to allow for the disabled worker to take that position. It becomes very complicated, but the basic issue I would alert you to is that the accommodation should fit the particular problem that is out there, and it needs to get to the essential functions of the job. And an employee who can't perform the essential functions, even with an accommodation, is no longer qualified.
And another thing to point out is that a lot of employers have or had policies in place where they would accommodate with light duty or modified jobs for individuals who are out on workers' comp leave. So we have a specific way that we deal with workers' comp because we want them to return to work because we're paying them for that time lost. And previously, prior to the amendments, the EEOC seemed to be okay with that, seemed to be okay with treating workers' comp individuals as a class different than those with disabilities. I don't know that that's necessarily true anymore, that if you have a policy in place that you accommodate with light duty workers' comp, but you don't accommodate with light duty individuals with disabilities, that's going to come under suspicion, and the EEOC is going to look very strictly at that, and whether or not that flies anymore. Probably doesn't.
So I think that kind of segues right into actually what Nicole's going to talk about in terms of leaves of absence as a reasonable accommodation, which I know is a huge issue that everyone struggles with. Again, pushback from business people who want positions filled, and Nicole's going to tell us what the EEOC thinks about that.
Well, and as Victor started to discuss, leave of absence is definitely a reasonable accommodation, and it's probably one that we're most aware of, is when someone comes in and says, I need X amount of time off for a person going through cancer treatment. I need X amount of time off for chemotherapy, for radiation, and then I'll be back. So certainly leaves of absence are going to be a reasonable accommodation. And as Victor spoke about, the question though is, does the leave accomplish the end goal? Does the leave put them in a position where they are then able to return to work with or without reasonable accommodation to perform those essential functions of the job? And an employer needs to be mindful that there's a difference between an indefinite leave request versus one where an employee gives an approximated return to work date or when the original date may change. Employers don't have an obligation so far to accommodate an indefinite leave. So if someone comes to you and says, I'm going to be out, I have a medical condition that qualifies as a disability, but I don't know when I'll be able to return, if ever. And you go through the process that Miriam described of getting the documentation to support what the medical condition is, and the doctor tells you the leave of absence is indefinite. Their prognosis unknown. Well, that's a situation where an employer can say it's unreasonable, it's an undue burden for me to accommodate an indefinite amount of leave, where you could come back in 6 months or you could come back in 6 years. That type of uncertainty we, as of yet, aren't required to accommodate. Even the EEOC guidance allows that. However, there's a difference between that situation versus one where an employee gives an approximate return to work date. So the doctor says, we believe that will be reevaluated in 6 months. Well, the doctor's not saying they can return in 6 months, but they're saying they'll be evaluated in 6 months. So there's a possibility they could return. In that type of situation, the EEOC is saying that's not an indefinite leave request. And there's a distinction between those. So in that type of situation, that's not one where we would be able to say, we can't accommodate this right out of the gate. We would have to provide that first amount of leave and then assess that situation at the expiration of the 6 months. The difference with the EEOC and the FMLA is the FMLA is straightforward. It's 12 weeks. The ADA places no limits on leave that may be requested. So there's a significant difference. And in fact, where we see this come up is when someone exhausts their FMLA. They go through their 3 months. Well, a few years ago, we used to say, sorry, you're done. You exhausted your 3 months, your 12 weeks of leave, and now you can't return to work, so we're going to move on.
Nicole, we actually have a question here, which kind of think goes right along with what you're talking about. Once an employee exhausts FMLA, what is a reasonable time to grant an extension to have under the ADA? 1 month, 3 months, 6 months?
Well, I think that's the million-dollar question. And unfortunately, a lot of my answers to the questions are, it depends. And I know how much people love to hear that, especially HR.
Especially from their lawyers.
Yes. And I think it's an issue that, the guidance that we've gotten from the EEOC is definitely 12 weeks of FMLA leave is a reasonable accommodation. Extending that beyond the 12 weeks is definitely a reasonable accommodation. So whether it's 6 months, whether it's a year, we aren't certain on, but we certainly know that it's beyond that, and it's a case-by-case basis. And having an extension beyond FMLA of up to a year is not unreasonable in the eyes of the EEOC. In fact, most recently, the EEOC has targeted their efforts against employers whose medical leave policies impose strict leave periods. They term it as an inflexible leave policy. A lot of times you'll see this where employers terminate after short-term disability ends. So we'll give you your leave, we'll give you your FMLA, 12 weeks, then we'll give you an additional amount of 3 more months to run the course of your short-term disability, and if you can't return at that point in time, then we'll part ways. We call it, nicely, an administrative separation from employment. That, up until a few years ago, was blessed by the EEOC. In fact, I had some cases and we won that on those types of policies. However, now the EEOC, through its guidance, has said that's a violation of the ADA, and that having a strict, inflexible leave policy is going to be violating the ADA. So if you take nothing away from this seminar but that, go back to your companies and look at your handbooks and see, do we have set leave policies that expire on a date certain? And if we do, then we need to put in some flexibility into that. We need to have some language that allows to engage in the reasonable accommodation process if a leave of absence beyond that date would be necessary.
I think that Nicole makes a great point, which is we used to write policies that absolutely put a date certain because we wanted you to be consistent and treat everyone the same way. Now we need to look at each situation. Is the doctor saying 6 months, 9 months? So we're adding some language to policies that may say, but of course we'll give you a leave up to 6 months, but we'll assess everyone on a case-by-case basis, which generally is enough to say, yeah, it's generally 6 months, but we're going to look at the situation. But you'd want to consult with your lawyer to make sure your policy is going to meet the pretty strict EEOC requirements.
And we gave you some examples here just to highlight the fact that the EEOC really has waged a war against inflexible leave policies. In 2009, we have Sears that paid $6.2 million for this type of inflexible leave policy. And the same just recently in last November, the EEOC settled for $5 million for this same type of inflexible leave policy. And I can tell you, so when we say when is enough enough, and I joke that that's the $1 million question, it really is the $1 million question. There isn't an answer yet. And I was just in Chicago at their regional office for mediation last week, and the EEOC ADR investigator actually said to me, this is what the EEOC is struggling with as well. the investigators themselves are struggling with this specific question. When is enough enough? Because it varies at this point in time. They have guidance that says it needs to be case-by-case basis. It can't be inflexible. There has to be a review of the circumstances. There has to be an engaging process, an interactive process. But there's nothing for them to determine, is 6 months okay? Is a year okay? Is 2 years okay? So they've actually taken some cases to court specifically to get answers as to how much leave is enough leave. So with this, I think it's sort of a wait and see at this point in time. And we're looking at, okay, what does the paperwork say that we're getting from the doctor? What does the documentation say? And how many extensions are we looking at beyond that? And it's really something we're going to have an interactive process. So what are the factors that you want to consider? So first, you're looking at, can the employee provide an estimated return to work date when they can perform their essential functions of their duties with or without accommodation? Again, indefinite leave, not necessary to be accommodated. But can you engage in that discussion periodically? Yes, and you should. So once you have that, you should follow up. Once you have a doctor's note, you should follow up with that as to what's next and what's required. Are there any limitations on those accommodations? So reasonable accommodations does not include removing essential functions of the job. If something's an essential function of the job, you don't have to give it to a coworker and say to that person, okay, we understand you don't have to do it. You don't have to create new positions. You don't have to provide personal accommodations, eyeglasses. And you don't have to change your conduct policies. You know, if there are behavioral workplace rules, people still have to comply with them.
Nicole, we have a question from the audience about if you have an employee on leave beyond FMLA, is the employer required to continue benefits?
If through the FMLA, you would have your benefits that stay and remain the same. So they have equivalent benefits. The employer does have an option of, once you've exhausted the FMLA, to put that individual on COBRA. And if they're going to go out beyond the 12 weeks of FMLA, you can cut off your benefits as far as what the employer provides and have that eligibility through COBRA. Again, you would want to do it on a consistent basis, and you would want to look at what's the time frame. Does it make sense for us to do this for every situation at the end of 12 weeks? Because if somebody needs an extra 3 weeks, do we really want to put them on COBRA for those 3 weeks? Maybe. But it probably works better to determine a set amount of time, that if somebody's out for a set amount of time, then we put them on COBRA.
I'll give you an example. A lot of my clients do that through a policy, an additional policy in their handbook, which might address disability and medical leave, which would be something that you would cover you after the FMLA period, and they might choose a set time frame. We're going to cover you for another month after an FMLA leave, or another 2 months, whatever is reasonable for the employer. But then they want to cut it off, and they want to do it in a policy so it's clear that we are consistently, if you go beyond the FMLA period, we are ending benefits in a consistent manner.
Can I just, I don't mean to go out of your process, but you're just talking about continuing benefits. The health care benefit, I understand, but what about the employee contribution of their part of the health care benefit? Suppose that, they're supposed to put in $150 or $200 every pay period, for their portion of it, and they're not working. Are we obligated to cover that still, or?
So for our webcast audience, let me repeat the question, and then Nicole can address it. It's during the time that the employee is on FMLA and after that ADA, what about the employee's own contribution to health care? And Nicole can go ahead and address that.
Well, when they're on FMLA, they would still be responsible for the employee portion of the health care benefits. And so you would set up a payment of how they're going to pay that in. And if they don't, you should put them on notice that if they don't make those contributions, they are in danger of losing their benefit. With undue hardship, we talked about that is a defense to reasonable accommodation. However, that's a very high burden. So I know that sometimes employers throw that out sort of flippantly saying, well, it's too hard. It would be undue. It would be undue hardship for me to do that. And that's a high burden of proof for the EEOC. And it's really not a cost-benefit analysis, which is a lot of times what we like to look at. One thing, though, that is given as an example for the EEOC is if it requires an employee to change, to stop work. So if I'm going to have a reasonable accommodation that I can't come to work till 9 and the shift starts at 7, and I have 3 coworkers who aren't going to be able to do their jobs from 7 to 9 because I'm not there, that's an undue burden. That's something that we couldn't reasonably accommodate. So when we have takeaways, a thing that we need to look at is where is the EEOC's focus right now? It's definitely on reasonable accommodation. It's on that expanded definition of disability. So the days of being able to say you're not disabled or you don't qualify as a person with a disability are over. We have the focus on inflexible leave policies as well as no-fault attendance policies. So if you have a policy where you just allow people to get points regardless, you need to look at that because that's going to be violating the ADA as well if someone is out for a reasonable accommodation and they get an attendance point. In fact, the EEOC's most recent settlement, it was $20 million with Verizon recently, and it was on a no-fault attendance policy. So be mindful of your policies and practices. To move on to when do you expect, if you suspect abuse, and it tends to be with the FMLA process. The FMLA had its 20th anniversary earlier this year, and they put out a survey saying that the employers generally find the FMLA easy to comply with, and misuse of the FMLA by workers is rare. And I find that laughable, that the fact that the FMLA is easy for employers to handle and to administer. So suspected abuse of FMLA, it's very prevalent. It's prevalent in many workplaces, many different types of workplaces. Employees are much more knowledgeable about their rights now. The DOL has websites, they have apps, they are very interested in social media engaging with employees so that they understand those benefits that are out there for them. And abuse is not uncommon. In fact, I just read an article and we were just talking about before we came on the panel today that there's a company that provides deceptive services on behalf of employees. So you, as an employee, can pay $55 to have a company substantiate your false doctor's note, to make phone calls to your employer saying that they are a physician's office, to substantiate your absence from work. So this is something that it's unfortunately not getting easier to, or it's something that's not going away. In fact, people are finding ways to make money on having leave, ways to violate leaves or have abusive leaves. So some of the things that we can do to weed out that abuse is to focus on Miriam's discussion of notice and designation and using your policies. Really, you need to look at your medical certification. Make sure you're requiring medical certification for absences under the FMLA and that you're fully reviewing it. A lot of times I see issues that tend to come up with abuse in intermittent leave cases where the doctor's paperwork says that the person will be out intermittently for flare-up, but under duration or frequency of absence, it's blank. Nothing's marked. So now the employee's been out 5 times in the last month and the employer's upset, but we don't have anything from the medical paperwork to say whether that's average or if that's unusual. So make sure that the documentation that you're getting is complete and that if it's not, you're clarifying. Make sure that you're using the tools that the FMLA gives you. You have the ability to get a second opinion. You have the ability to get a third opinion, but it's at that original certification stage. If you have somebody who comes in with migraines and they have a certification that goes throughout the year, it's intermittently, and you decide 2 months in, I don't think this certification is working out. I want to get a second opinion. I'm not sure that this guy really has migraines. Then you have to wait until 6 months to get the recertification, and you don't get a chance to have a second opinion on a recertification. You have to wait the full year. So make sure that you're putting controls in place, that you are requiring employees to follow your procedures, you are communicating with employees about their leave status, and that you're tracking absence patterns. If the FMLA paperwork says that they should be out once a month and it would be 2 to 3 days for a flare-up, and you find that they're out for full weeks at a time, well, we need to track that. We need to follow up on those absences. Why is there a difference in what the paperwork says versus what's happening?
And that's the situation where you see a pattern of absences that may not be consistent with the doctor's note. So someone has, I always like the migraine example. How is it that employee is able to call in the day before their scheduled shift to report a migraine? Or why do the migraines, this is another one, why is it that the diabetic employee only has flare-ups on Friday and Monday? We actually, my client had a situation like that, and we actually, of course, got to the doctor to say, is this consistent with the employee's condition? You would think that the flare-ups would be random, and of course that's what the doctor said. So the doctor recertified in that case. But so, you might not notice them at first, but after a while you'll start to see a pattern of preferred days, Saturdays or whatever it is. And that may be where your supervisors need to give you some input. I mean, you're not there on the ground seeing what people are doing all the time. So it's important that they understand what their role is. I think Victor had a question that he received.
We received a question. It also involved diabetes, actually. It says, what do you do when you have an employee who has an illness like diabetes and is clearly having issues standing, walking, and remembering job duties? How do you approach this employee about their condition? I think those are excellent questions, and I think it raises one of the problems that comes up frequently under the ADA, which is an employee who has reported a particular condition does not request particular accommodations, but it appears as though they're unable to do certain functions of the job. How do you as an employer deal with that?
So that's a situation where you can, if you have a concern about the employee's safety, under the ADA you can actually require that the employee have a medical exam. I might not start with sending the employee for a medical exam. I would probably approach the employee about what I observed and ask them, give them some documentation, the kind of questionnaire I talked about earlier, and say, I want your doctor to weigh in on these issues. Get the feedback from their doctor, see if we can accommodate, and if the employee is uncooperative, won't submit to their doctor, because sometimes that happens, then I might send them for a medical evaluation. Because right now, remember, we're not talking about FMLA, where we are limited in what we can do. We're talking about being able to perform the essential functions of the job. So we have a little bit more flexibility under the ADA to get that medical information and try to come up with an accommodation. But if the employee rejects the accommodation, then you may have some hard decisions to make if they really can't perform the essential functions of the job. I have a client who had an employee who had a very severe neurological disorder. And this is one of those really sad situations where employee wanted to keep working, but he just physically couldn't do the job anymore. And we had to kind of bring him along and help him understand that it was dangerous for him to continue to do the functions of the job through a process of talking with his doctor. So you've got the fraud and abuse situation that Cole's talking about, and you've got an employee who is committed to his job, and you have to unfortunately help ease that employee out because they can't do the functions of the job anymore.
Mm-hmm. Well, and to follow up on Miriam's point about making documentation important, right? We have to follow up. We're not medical doctors. We need to have a physician certify to us what is going on with that individual. And so the example that I give for the suspected abuse is something that we touched on briefly before, is someone who has a series of suspect absences, now all of a sudden is on the verge of termination or disciplinary action because of those absences, and they say, well, it's FMLA related. And so you give them the paperwork, and she doesn't return the paperwork within 15 days, and then you give her not one, but 2 extensions to return that paperwork, the FMLA certification paperwork, and she doesn't. And the employer terminated. And guess what? The court said That's okay. It's not a violation of the FMLA. You have obligations, employee, just as the employer has obligations, and they're time sensitive. So the FMLA does give employers a few tools to use, so make sure that we're being diligent in using them. Another example that we give is in FMLA absence, it's intermittent leave for depression. They call the supervisor and simply says, I won't be in today because of FMLA. Well, what do you do as the employer? You know that they have certification paperwork. You know that it's detailed, that there are going to be intermittent flare-ups and there would be absences. But what can you do? Well, this is one of those instances where we talked about as to setting in place policies and procedures for dealing with intermittent FMLA. So, and I hate to say it this way, it sounds mean and nasty, but make those employees jump through hoops. Especially those conditions that don't require going to a doctor, right? That tend to be intermittent FMLA. Set up intermittent policies, and these are your call-in procedures. So you can ask questions. If someone's going to be absent, you can ask questions about it. You can have them call in and have to call at a specific time and talk to a specific person. You can ask the reason for the absence. You can ask, what are the duties of the job that you're unable to perform today? You can ask, are you going to go see the doctor? Do you intend to see the doctor? If you do, bring us a note. You can ask, when did you learn you were going to be absent? To Miriam's point, if they say migraines and they called the night before, how did they know they were going to be out for their morning shift the night before? So again, there are some things that we are able to ask. We can say, is this going to be a full day absence? Do you think you can come in later today? If you are able to come in, love to have you come in on even a half day. So again, it's putting those policies and those call-in procedures in place for intermittent absences, intermittent FMLA absences. Another example that we give is to Victor's point that back pain tends to be the most frequent certification that we see lately. And this employee says he's going to be out once every 3 months. Curiously, the employee's back pain tends to flare up on the days just before or after his scheduled time off, so he gets an extra day on vacation without using a vacation day. He uses them around holidays, and even in his own birthday, he happened to have a flare-up of the back pain. So these types are situations where this is something you can document. You can track this patterned absence and determine, is this at odds with what the certification paperwork is? And in that type of situation, you have, as the employer, the recourse to get a recertification paperwork, recertification of the need for FMLA.
What I usually do in that situation is attach the list of absences with the recertification and include, I typically use not the standard DOL form for a certification, so I include another question on the certification form that asks about why there's a pattern of absences and how it's consistent with the condition. Even if it's not even necessarily for the doctor, it's really to let the employee know that we're on to what they're doing, and at least it stops it for some period of time. But once the employee knows you're on to them, hopefully that addresses it for a little while.
Another example we gave is there was an RN in this circumstance. It's actually a case of that she was on FMLA to recover from lower back pain, and it was that she was unable to walk or stand. However, during her FMLA leave, she posted on Facebook pictures of her on vacation, walking around, playing volleyball, having a great time. She later claimed she used a wheelchair, just didn't happen to be using it on that specific vacation, but later admitted, well, no, I didn't really use a wheelchair. The employer terminated for dishonesty, and you know what? The employee won, or the employer won. The employee was terminated. They found that the employer had an honest belief that they were violating the FMLA or abusing the FMLA. So this tends to come up in situations from HR gets notice or managers get notice from coworkers. Coworkers are the first ones to rat out the person on FMLA. And it tends to happen through social media. So if they're posting pictures on Facebook or tweeting, What I would make sure you do is that you get some kind of documentation. If the employee who's telling you this information can provide you with the Facebook, printout where they saw that this person was on their Mexican vacation or was at another case of Polka Fest dancing. So you have something to put in the file to demonstrate your honest belief. Because right now courts are saying that the question is whether the employer made a reasonably informed and considered decision before taking the adverse employment action. So if you have a good faith belief that there is abuse going on, that would be a reason to terminate that leave. So the takeaways really are that the legal and regulatory environment for employment law is really ever changing, and it's very important to keep up to date on those changes and how they're affecting your workplace. So that includes monitoring your policies, making adjustments when need be, and really training your managers, because they're your first line. They're the people who know the most about their direct reports and what's going on whether it's the shop floor or the call center or whatnot. And they're the ones who hear about the medical issues. So you want to make sure that they're responding appropriately and directing them to the individuals who will be able to handle those matters.
Yeah, I would absolutely say that where I see, and I hate to call the first line supervisors a weak link, but it's just because they don't know. And there are a lot of misconceptions about the FMLA and the ADA. And they're busy with other things. So if you can give them even a little bit of training and direction, or make them feel comfortable coming to HR about it, I think that would absolutely limit risk and help you manage FMLA and ADA. We hope we've done that today as well. We are at the end of our session. If you have additional questions here in Cleveland, we're absolutely happy to help, stay and discuss them with you. And we have a couple that we didn't get to, so please come up and talk with us. If on our webcast you have additional questions, please email them and we'll respond. And I also want to point out that we continue to follow the latest developments in labor and employment law. You can see this is an area that we're interested in. We want to help you. And we also have available our business advocate, which you can access at businessadvocate.mcdonaldhopkins.com. The URL is on the front of your brochures and on your information on the webcast. You'll receive a survey. Please fill it out and let us know how you enjoyed our program. And thank you for participating today.